Walking through the city, lights all aglow. Everybody's got a story to show. Wheels keep spinning, streets overflow. Hustle never stops, we're in the flow. Skylines high like our dreams in the air. Concrete jungle, we got flair. Rhythm of the night, we don't care. Underneath the stars we breathe rare. In this urban jungle we're alive. Heartbeats echo as we strive. Dreams collide where the streets survive. Together we'll thrive, side by side. Echoes of the past linger near. Future calls, we face it with no fear. Every corner tells a tale so clear. In the city, we chase what we hold dear. Shadows and whispers blend in the night. City's pulse beats with all its might. Lost in the chaos, but it feels right. We rise above, reach new heights. In this urban jungle, we're alive. Heartbeats echo as we strive. Dreams collide where the streets survive. Together we'll thrive, side by side.
And kia ora, good afternoon to today's Order Paper podcast. I'd like to say Laura's not able to make it, so Stacey is stepping in for Laura, and we've got Jordon who's joined us, who was at the Parliament on day one of the Treaty Principle submissions. How's everyone this afternoon?
Oh, surviving.
Surviving.
Well, I'm in Hoipira in Te Whanganui-a-Tara in Wellington. This is Te Wānui-a-Tāne behind me in the new cardiac ward in Ward 7.
Nice. Oh, yes, because you've had a lot of fun of being unfortunately stuck at our great hospital.
Let's not say great so far.
Well, at the moment, it's still public.
Yeah.
Yes, at the moment it's still public.
Yes.
And let's keep it that way too.
Oh,
you know?
certainly right. Yes, you are so right.
Absolutely.
Since Thursday, they thought I was a 70-year-old man from Woodville called Alan Johnson. And I am Jordon Marshall Wansbrough, and I was born on the 27th of the 1st, 1990. I was not born in 1940-something.
Gee, you were born 4 days after my stepbrother Louis.
Oh, wow.
That is, yeah, because he's 17th. Yeah. He's the one who's the weird thing is like how Louis was the 7th of January and Hayden ended up being the 16th of January. It was,
Wow.
the weirdness of how it goes with siblings. Now, for some unusual news and talk about random coincidences. So today, this post appeared on Newtown Peeps. Now, this is a local community Facebook page that I'm part of. Just heard that David Seymour is sitting on a panel to discuss Treaty at Newtown School at 3 p.m. Has anyone else heard this? And it's like, as you can go through the comments, I actually think this show that was doing a 3 p.m. special got mixed up with it, considering our first person we're covering in that is, ironically, David Seymour. So yeah, I wonder if it, yeah, but it's like people there, like one person said, where do we get our eggs? I'm not sure eggs at the
I
moment.
don't talk about that one.
You know, they're pretty expensive at the moment, eggs.
Yes.
So yeah,
And that fella in the middle was the one that stopped the submission hearings because I did a mihi tautoko to Dr. Ganesh Nana, Indian
James
migrant that
Media.
was born in New Zealand, who was opposing the Treaty Bill.
Yeah. Well, let's we've had our fun, weird, what the hell is going on moment, and
I
to our first bill, our first submission, or should we say, from the minister.
Live. Morning, sorry. So good morning. Just as a bit of a preamble, welcome everyone to the Justice Committee's public hearings on the principles of the Treaty of Waitangi Bill. Just before we begin with the Minister in charge, I'll run through just a short piece of housekeeping. The schedule is very tight, so we'll be sticking strictly to the timing for submissions, and that includes the on-screen time that people will be able to see. So members just can be wary of that when asking questions to keep it as succinct as possible. We'll have a break at 12:30 for half an hour, but otherwise we'll be running straight through. So thank you all for being here. We begin today's session by welcoming Minister in charge of the bill, Honourable David Seymour, to make a presentation. So Minister, welcome. You've got 15 minutes, so please begin your presentation.
Okay, well, first of all, thank you to the members of the committee. I know that you're going to have an extensive discussion with 80 hours of hearings, and I believe it is a great day for New Zealand that our treaty is being debated. In a free society, people should be able to have their say about the most important issues of the day and all of the laws under which they live. Perhaps one way that I can be helpful through submitting on this bill is to explain a little bit about the why, the motivation for bringing it here, and what I hope that it will achieve. And I want to start that by quoting a passage from Hansard, which says that we meet today at the pinnacle of several centuries of progress. We have moved towards the light of liberty by removing distinctions in law that once treated people differently, depending on their religious conviction, their gender, or their race. And most recently, this Parliament has decided to remove gender from the marriage laws. Many countries have never achieved that, but it is extraordinary that as if engaged in some form of historical shuttle run, it was we who were first to touch the cone that are now rushing back to create new distinctions in law. I refer to those who claim that the only way to achieve material equality between the Maori side and the British side of my ancestry is to create more legal inequality. No doubt they have noble intentions, but public policy should be measured only by results. That was me just over 10 years ago, 31 years old, in my maiden statement to Parliament. Now, you might think that a little bit indulgent, but I want to be clear that my beliefs behind this bill and my belief in freedom under the law is a long-held and sincere belief. What we've witnessed in recent decades as the courts and the Waitangi Tribunal have sought to define the principles of the treaty is incompatible with freedom under the law, with a free society where each of us have equal rights. Since the Court of Appeal said that the treaty created a, quote, partnership between races, or a relationship akin to a partnership, that notion has become commonplace. Dame Jacinda Ardern, as Prime Minister, just 5 years ago, quoted this idea of a partnership between races at Waitangi. Members of our current Parliament believe that this country would be better off as a, quote, Tiriti-centric Aotearoa, where people are divided into tangata whenua, land people, and tangata tiriti, treaty people. Just this summer, we saw a concert where the ticket prices were differentiated, with different prices for tangata whenua and tangata tiriti, with different amounts to pay. We see consultation on resource management consents, the structure of local government, and some central government departments taking this divisive approach. Dividing people into racial groups is the definition of racism, just as sexism is to judge a person first by their sex and then by their other characteristics. Their belief that roles in society should be preserved with race as the primary qualifier is the definition of racism, something we abhor, should give nothing to, and should all do everything in our power to expunge from our society. When you see people as a member of a group first and an individual second, you miss interesting things about them. You also open the door to dehumanizing oppression. It reminds me of Plato's chilling republic, where people are divided into classes, forced to act in certain ways in order to preserve the totalitarian state. Now, we're certainly nowhere near that, but it reminds us of the direction in which you travel once you go down this partnership between races conception of our founding document. Now, I have no doubt that you will be told that freedom and equality under the law are not actually that useful because they do not guarantee material equality. They don't guarantee that everybody will have equal wealth, or perhaps in some cases, even sufficient wealth. 2 points about that. First of all, no, freedom under the law doesn't guarantee wealth. It doesn't guarantee material equality. But what it does just so happen to do across a range of times, cultures and places is create the best opportunities in human history for disadvantaged people to achieve prosperity. And that is, there is so much data on that now across many countries, many decades, many centuries, that people who deny that really aren't taking the conversation seriously. The second point is that even if the treaty as a partnership is put forward as a way of helping to achieve material equality, you'll find that it is not necessary, nor is it sufficient. It's not necessary because it is possible to help disadvantaged people without dividing a country into two groups based on ancestry. Practically every country in the world, to some extent or other, is in the business of trying to help people through government intervention that need help. But second of all, it's not sufficient to create material equality within New Zealand because many people who are not Maori are nonetheless disadvantaged. And I could come up with many examples, but none more poignant than the fact that today is the 80th anniversary of the liberation of Auschwitz-Birkenau. And just yesterday, I joined with the New Zealand Holocaust Centre to commemorate that anniversary with several people who were survivors who sought refuge in this country. Now, that is obviously an extreme example, but it makes the point that many people, for many reasons, find themselves in New Zealand disadvantaged. Not all of them are Maori, in fact, far from it, and not all people who are doing well are not Maori. Using race or ancestral background as a way of deciding who needs help is simply ineffective. You may also be told that this Parliament does not have a right to make a law on this bill, make a law about the treaty principles. That really goes to the heart of the debate. If you believe that New Zealand is some sort of constitutional oddity with two partners and different people having different political rights based on their ancestry, then of course you won't want Parliament to make a ruling about what the Treaty of Waitangi means to us in the current day. If, on the other hand, you might be tempted to ask those people, first of all, what are they doing here? Second of all, how exactly would they like this society to work? And where are the examples of societies that divide people by ancestry that are more successful for it? And finally, you might want to ask them, have they met the billions of people around the world, many of whom are fighting right now, very literally, for parliamentary democracy? Those people would very much like to have a parliament like this that is the arbiter of what our laws mean in the modern age. And finally, this bill, some will say, may not pass this time. We shall see. But I can tell you that you are part of something important and inevitable. In the past, in parliaments, including this one, we've seen, for example, the end of slavery first introduced in, I think, 1792, eventually passed in the early 1800s. We've seen homosexual law reform first introduced to this Parliament in about 1973, passed in 1986. We've seen end-of-life choice first introduced in 1995, passed in 2019. Once you have an idea that relates to emancipating people and freeing them from systems that oppress them by giving some privilege to one group at the expense of another, which the partnership principle most certainly does, then eventually the tide for human freedom, the tide that people will want to join because they see that each of us are born with time on earth to make the most of our talents so we can be as happy and flourish as much as possible in that time that is ours and ours alone. That idea eventually will succeed. And the work that you do over the next 80 hours of hearings and the next 5 months of deliberating, I believe, will make a very important contribution to that movement. So I hope that you will enter into it in good spirit and do it well. And also, having sat on 1 or 2 committees in my time, I have tried not to make the mistake of talking for too much of the allocated time so that there can be questions.
Thank you, Minister. We do have time for questions, first from Ginny Anderson and then Debbie Ngārewa-Peka.
O tēnā koe, David. Nau mai haramai ki tēnei committee. Ko taku pāta kia koe e pāna the second article of the Treaty of Waitangi. I'd really like to hear from you, your understanding of what the second article of the Treaty of Waitangi means to you, both in the English and in the Te Reo Māori version.
So first of all, the Maori version guaranteed te o rangatiratanga over the paonga that Maori had in 1840. The English version was a little bit more specific in its language, talking about lands and villages and fisheries and so on. I always rely on te tiriti, and specifically on Professor Kafu's translation of it into modern English in 1987. The definition of taonga obviously has been something that's been debated over the years. Should it, for example, include radio spectrum as a taonga, even though that was not a technology that anybody was using in 1840? What this bill does, however, is make it clear that we are committed to continuing to honouring the rights that hapu and iwi Māori had in 1840. What we'd like to do is ensure that that happens within a democratic framework where each New Zealander has the same rights to make claims to their property, to their language, to their culture. And so we're committed to protecting Māori rights, but within a framework of equality before the law for all.
Thank you, Minister. I'll go to other members. Debbie Ngare, back again.
Tēnā koe, David. My question is, if the Treaty Principles Bill, or the Treaty Principles are removed from legislation, how would Māori rights and interests be protected in areas like health, education and resource management?
Well, they would have exactly the same rights as any other person in this country. It might interest you to know that shortly I hope to visit Te Rito in the far, far north. This is an organisation that runs now 4 very successful early childhood centres for Māori, and what they've managed to achieve is winning the trust of local people. Being from Northland, scepticism against government is alive, well and very healthy. What's important is that we haven't done this in a way that is only for Māori. It doesn't rely on being a part of a partnership. There's actually 7 partnership schools opening in the next few days for all different groups and backgrounds. Some have an ethnic link, others don't. What's important is that in order to help all people, we need to do much, much better in the housing market, in the way we provide healthcare, in the way that we provide education. That can be achieved with a lot more devolution. It doesn't require us to separate the country into a partnership between 2 races.
I'm just conscious that we're really shy of time.
Sure,
if I can just supplement and clarify. My question was actually specifically about Māori rights and interests and how they would be protected. But I guess if I could follow up on that, is then how would this bill improve outcomes for Māori communities who already face significant disparities? And how will this bill ensure Māori are not further marginalised?
Well, first of all, how would it improve outcomes for Māori? I think having a free society where everyone's equal before the law, where you can get a resource consent to build a home for someone or start a business with less of the rigmarole that many people complain about right now because I've effectively got 2 consultation obligations. That is prosperity. That is good for all people. How would it protect?
I specifically asked for Māori communities, Minister.
Well, I think the difficulty we might be having here is that I believe that Māori communities, Māori are people, we are New Zealanders.
And we have our own
And in a more,
Okay.
yes, a lot of people have their own community, but in a society with greater prosperity, greater growth, where it's easier to own a home, where we have more devolution and flexibility of social services, it actually benefits everybody. So we don't need to divide ourselves by race.
So the
in order
Minister
to
doesn't
achieve.
acknowledge Māori communities. is
Sorry,
that
Debbie,
what you're saying?
we'll end up on that point. We'll go to Tamara Ball, probably the last question.
Morena. My question is, so in your speech and in your interpretation and understanding of the treaty, why is it that you continue to subscribe to the same belief that the treaty was signed between races, despite the fact that so many academics around the treaty continue to reinforce the idea that the treaty was signed between 2 sovereign nations, but you continue to criticise people's use of race? But that is the same logic that you apply to your interpretation and understanding of the treaty. So why is it okay for you to do it and nobody else?
You've actually got 3 different ideas here. First of all, let's get the historical fact. The treaty was signed by just over 500 chiefs on behalf of their hapu. Some of them had also signed He Whakatuputu, the Declaration of Independence. Others had not. There was a lot of disagreement within Māoridom. They signed on behalf of their hapu. That's the historical fact. The idea that there was 2 sovereign nations, I'm sorry, I don't subscribe to that. The third idea you've introduced is one that you have said that I adhere to, that it's a partnership between races. And I'm against that. When I say that, I'm quoting the Court of Appeal who said that. I'm quoting the
Thank you,
people who
Minister.
say we
Sorry to
should be
interrupt,
divided.
but we've reached the end of time for our hearing. So I'd like to extend our appreciation for you being here and wish you well.
All right. Thank you very much, and good luck, guys.
It feels like he was very much didn't like to deviate from its talking points.
Yeah. It really does.
He doesn't even know what he's talking about.
Well, I found that quite interesting to state that, but I don't believe there was a treaty between 2 sovereign nations.
No, it was a dominant nation already. We were sovereign. We've never given up our sovereignty. Tino Rangatiratanga is still our sovereign. You know, we have Tino Rangatiratanga. We have Haitiakitanga. We have all those tangas that connect us as a Māori people, but we're not Māori. We were never Māori. Māori means original or normal.
Yeah.
we were tangata whenua. And before that, we were tangata moana. And before that, we were tangata huri. We came from ancient Peru, Egypt, China, Japan, all over.
Yeah. Yeah.
We settled here in the South Pacific because it was a great place to settle.
Yeah. Now, were you in the select committee room at this point of the hearing or not?
No, I was in there in the afternoon.
Okay.
So this is early in the morning. This is 8 a.m. in the morning that this happened.
Yeah.
Or 8,
Oh,
between
well,
8 and 9.
according to the clock in the background. Yeah, well, actually, that's the next clip we're looking at. Should we get to some fireworks from Gary Judd?
Oh, this is good. Yeah.
I'm not sorry?
Gary Judd.
Oh. I think I was like at 30.
That's all the time we have. So just
23
acknowledge your submission.
minutes
Thank
or
you,
something. I have a
today.
look. I took a.
We'll move on to submission now from Mr. Gary Judd. Casey, I invite Gary to the table.
Oh.
Apparently,
Thank you, Gary. Good morning. Welcome to the committee. We have you for 10 minutes
happened.
for us this morning. So if you'd like to begin
Yes,
your
thank you,
submission,
Mr Chairman, members of the committee, for this opportunity to address you. I'm going to be very brief in my introduction and allow most of my time for your questions. And what I want to address is the sovereignty of Parliament. In the last submission, you heard what was another challenge to it. And in my submission, we have a situation where the sovereignty of Parliament is under challenge in the courts and from members of the legal profession. One of their weapons is the undefined principles of the treaty. The bill, if enacted, would remove that weapon. The behaviour of some of our senior judges suggests they think they are entitled to make law, to ignore Parliament's laws or to twist them into a shape they find more congenial. The most recent judicial excess occurred on the 2nd of December last year. In the Edwards case, the Supreme Court was so eager to try to frustrate the progress of the Matter Amendment Bill that it rushed out what it called a judgment. It wasn't a judgment, it was a pronouncement that the court had no jurisdiction to make. When the court announces the outcome of the claimant's claims, only then will there be a decision. 42 KCs warned that the courts might not enforce this legislation. Opposing the bill, the Law Society claims that the treaty and the principles limit Parliament's lawmaking power. In our free and democratic society, ultimate power rests with the people. They exercise their power by electing you to represent them. And that is why Parliament is sovereign. The lawyers think the Supreme Court has the ultimate power. The Supreme Court has been acting as if it thinks so too. They see the ordinary people and you, their representatives, as untrustworthy decision makers who can be second guessed by persons implicitly claiming superior intellect and wisdom. Parliament should be jealous of its sovereignty and be clear that unelected decision makers must act in accordance with the law and accept the sovereignty of Parliament like everyone else. The bill stops the principles from outflanking the sovereignty of Parliament. My proposed amendment to the Lawyers and Conveyancers Act would remind lawyers of the duty they owe to New Zealand's Constitution. The rest of my time is for your questions.
Thank you, Gary. Members, we've got time for questions. I'll start with Todd Stevens.
Thank you for your presentation. Just so I'm clear, basically, as I understand it, Gary, what you're saying is because Parliament left the principles of the Treaty of Waitangi undefined, there's now been obviously this kind of jurisprudence and also governments have actually said what the principles are. So are you, in your opinion, it's quite legitimate for Parliament now to be able to go back and define what the principles are?
Yes, absolutely.
And then you mentioned at the start also this attack on parliamentary sovereignty. Because again, this is, I think, and again, we heard this in the last submission, the idea that actually there should be basically two governments for New Zealand. But it's just one of the issues with, because again, in 1989, the Labor government, as one of its principles, so again, a government just stating what the principles are, actually said that Parliament was sovereign. So is this one of the issues with not having a definition, is that principles can change over time and people are uncertain?
Well, they can change according to the whims of those who are dealing with them at a particular time. And I think it all comes back to the fact that Parliament is sovereign, representing the people. It must make the laws, and in respect to the principles, it must say what they are. If Parliament doesn't do that, then it just leaves a vacuum which may be filled by people who wish to push their own barrows.
Thank you. Thank you. I'm as guilty of this as any other. If we can try and keep the questions relatively succinct, we'll get through. We have a question from Duncan Webb and then Tuck Ferris.
Jordon, thank you for that, and I will keep this short. I'm just interested in terms of your views of parliamentary sovereignty, because I guess my question is this: do you accept that Parliament in part gets its authority to govern from the Treaty of Waitangi, and if so, how is it then appropriate to go back and rewrite it?
No, I don't accept that Parliament gets its sovereignty from the Treaty of Waitangi. Parliament gets its sovereignty initially from it having been conferred by the United Kingdom or British Parliament back in 1840, and what the treaty did was to indicate the assent by the chiefs who signed that they were accepting of that happening. Of course, you have to remember what the situation was.
So how did the British Crown get the right to assert the authority of Parliament, which of course didn't happen until the 1850s, over the territories of New Zealand?
The British, we're really going into a history lesson here, but when the British were initially asked to intervene in New Zealand's affairs by the chiefs, and as a consequence, Busby was sent over as the resident, the British became involved in a governmental way in New Zealand, and then as a
Look,
result,
I don't think you can answer that question. It's probably appropriate to give a question to another member.
Thanks, Duncan. I'll chair the meeting from here. Thank you. Mr. Judd, are you finished with your answer? If you are, we can move on to the next question.
No, I'm finished. Didn't really come here to talk about
Thank you. Question now from Tuck Ferris.
Morena Matua, thank you for your time this morning. I'm just wondering if you agree with the notion that actually countries are sovereign and parliaments are actually sovereign by virtue of an act of their own making. Would you agree with that?
No, I think that sovereignty resides with the people. They have the ultimate power, and in a democracy, the people represent others elect others to represent them, because from a practical point of view, the people cannot, as a great big group, govern. So they have to, in effect, delegate their authority to representatives. But the point is that the people are ultimately sovereign. That's what democracy is all about. And if we want to have and retain a democracy, then we must be firm about that, and we must reject as firmly as we possibly can any suggestion that any particular group of people within the country have power over others other than the elected representatives.
Well, I see we're down to a minute, Matua, so I might just ask you one more. I agree with your point that the peoples are sovereign. And Te Treaty of Waitangi is a document signed between two sovereign peoples, the original sovereign people of this country, Māori, and the monarchy of England, the Queen of England at the time, who represented her sovereign people. Would you be happy with that characterization of the Treaty of Waitangi, the coming together of two sovereign peoples? And if you are, do you think it's okay that one group changes the deal without informing the other?
Well, no, I don't agree with that characterization, because it's impossible to characterize a collection of warring peoples as
the British, you mean the European warring peoples?
No, I'm talking about the various tribes who were fighting all around the country from time immemorial,
in Europe,
in particular within the years preceding.
Gary, unfortunately, that's the time we've got for the submission. So I'd like to acknowledge your submission and thank you for being with us here this morning. Now,
How the hell did he? Well, he probably is an experienced lawyer, just doesn't quite like.
Do you know what I don't like? Is we've got all these lawyers and doctors that aren't even Māori speaking for Māori or tangata whenua, when they don't even have a clue about tikanga o kawa. They may have a doctorate about it, but they've only seen it in the books. They've never been on the marae. They've never gone to the kaumātua. They may have, but they've got their information from it, but they've used that to their advantage. But they've never gone and picked up a tea towel, or they've never gone into the back of the hangi pit to pull out the hangi.
Oh no, I haven't even got that far.
Or even buried someone in the urupa.
I like my hangies, but no, I don't think I got that far. But yeah.
Yeah, no.
Oh well, Sam, I'm going to have to bring you back to the marae to make a hangi, eh?
You sort out a time, and I am very open to it, as long as you make it a Sunday.
You know, something I noticed on Friday when I was watching through literally all of these is that a lot of people show that they might have learned experience, but they don't have lived experience.
Correct, because they're not Māori.
Notice that there is a difference.
Exactly. Yes, so much. And it is so many people who, you know, a textbook approach on something is very different from literally learning it. Like, put it this way. Oh, I've never driven a manual before. I've only ever driven automatics, but I understand how a manual works compared to someone who goes, I've driven manual all my life. I actually know how manuals work, and I know how gearboxes properly operate. I don't just put the Prindle in D and drive off. and anyone remembers the Prindle, that would be off the Sweet Life of Zack and Cody of London, one of London's ways of calling it. Shall we move on to the New Zealand Māori Council? And I think Jordon's having his lovely fun of going backwards and forwards again.
I think it's when he's looking at something else on his phone, it's just popping him out for a moment.
Yeah. Oh, yes, it does that. Yes, I remember that when I was like seconding just watching it on a smartphone. It was an absolute pain in the butt of going through there.
Yeah. Are they the next one?
Yeah, sorry. That's all right. We were trying to line up the next one.
There we go.
So thank you. Well, welcome
So is my
to the
kōrero
room,
in there? Because I think it's been taken out.
Jury, who's joined us in the room, and your colleagues.
I don't know.
Thank you for being with us. I will hand over to you for the next 10 minutes to make your presentation.
Thank you, Mr. Chair. We have another person, Anne Kendall, who will introduce for us.
Can you hear me?
Yes.
Okay. Morena, tēnā koutou katoa, the Chair, Deputy Chair, and members of the committee. Thank you for hearing us. I am Anne Kendall. I am co-chair of the New Zealand Māori Council. On screen are the Council's PO, or patron, Sir Taihakurei Jury, the Secretary, Donna Hall, and the lead researcher, Dr. Betsy Martin. I will introduce you to the Council and to Sir Taihakurei Jury, who alone will speak to the submission. The New Zealand Māori Council is a statutory body that has been constituted under the various statutes dating back to the Māori Council Act 1900. Its unique feature is that it represents hapu as the traditional governing entity of Māori society. But with changing demographics, the Council today represents both traditional and modern Māori committees. Its current statute is the Māori Community Development Act. It strives to make government aware of the community opinions and communities' awareness or aware of government policies. It operates through 16 district councils and 138 elected Māori committee groups. The Council has assisted the development of treaty principles through many proceedings in the Supreme Court, starting from New Zealand Māori Council versus Attorney General, recorded in the 1987 New Zealand Law Reports. Sir Taihakurei Jury, who has been a judge since 1974, was chair of the Waitangi Tribunal from 1980 to 2000 when he was appointed to the High Court. The foundational principles of the treaty were developed during his tenure, and I will now pass the vako to Tātai Hakure Jury.
Thank you, Anne, and Chair and members. My name is Tai Hakure, and I am from Ngāti Kaupapa of Manawatu. The Council opposes the bill, but welcomes the debate. I will make just 3 observations. The first is that the bill ignores 50 years of examination of cases that inform the principles of the Treaty of Waitangi by well-qualified Māori and Pākehā of the Waitangi Tribunal, which in my time had 50% Māori and Pākehā, and by senior judges of the High Court, the Court of Appeal, the Supreme Court, and the Privy Council. Numerous governments have not sought to challenge those findings. They have been the subject of regular reports to the United Nations, and they align with similar findings internationally. My second point is that the principles of the treaty, as described in the bill, do not in fact reflect the purposes and intent of the treaty as recorded in both treaty texts. They are not, therefore, treaty principles if they do not emanate from the treaty.
No.
There is an extraordinary ignorance in presuming otherwise. If this bill were to pass, I believe that our government would be the laughing stock of those of the Western world who understand how responsible states today seek to manage relationships with their Indigenous people. Mr. Chair, those are my only observations. We are actually more interested in your thinking than our own, and I would like to use the rest of this time for questions.
Kia ora tai Hakure, thank you for your submission. We'll go to questions from Joseph Mooney, then Duncan Webb, then Steve Abel, then if we've got time, Mani.
Tēnā koutou katoa. Look, I was just interested in reading your submission where you discussed Principle 3.1 about everyone being equal before the law, and that you pointed out in that submission that this actually came from the Magna Carta. And you don't say this in your submission, but that principle that the king and his government are not above the law. Have you read Archdeacon Henry Williams' letter to Bishop Selwyn in 1847 where he said he thought that the treaty was the Magna Carta for the Aborigines of New Zealand?
I haven't read that particular one, but I've heard that comment quite often, that the treaty is the Magna Carta. But I think what the Magna Carta was really trying to do was to preserve the rights of all people. And that is also what the treaty is trying to do. It is trying to reserve the rights of Maori that existed prior to the Europeans being here. So the objective was to provide for both peoples.
Thanks.
Sorry.
Sorry, move on. And we'll take stuff through the chair as well. Thank you, sir. We'll go to Duncan and then Stephen.
Kia ora, Rangatira. Read your submission with real interest. There's one bit I'd like you to comment further on. You talk about the treaty being a series of promises by the Crown to Māori. And you infer that there are therefore things that Parliament, the New Zealand government, doesn't have the authority to do. Can you explain how you see the treaty as essentially a constraint on Parliament's authority?
Yeah, I think in that context, we really have to talk about parliamentary sovereignty. I believe it's a very outmoded concept. We should not be talking about it in this day and age. Sovereignty means that one has all power to do everything. Now, that may have suited the people who lived in the 1900s, but I do not think it can be a proper approach for our times, where we must be talking not of parliamentary sovereignty, but of parliamentary responsibility. So that if we look to Israel, for example, we can say that Netanyahu could have all power. It's not the point in this day and age. The question is, how can he best achieve things on a responsible manner of acting? The next point is that governments are all constrained. Donald Trump is constrained by the American Constitution. It was the American Constitution that got the American people through that dreadful attack on the Senate. You are immediately constrained when you have a constitution, and we do have a constitution. You are constrained when you enter into or sign up to a provision of the document of the United Nations. You agree to behave in a certain way. there is nothing unfamiliar with the fact for lawyers that governments are constrained in some way. And yes, this treaty was putting a moral constraint on the government as to how it would behave.
Thank you, Sue. I'll take one final question from Steve Abel.
Yeah, just you speak about equality and equity. How do you respond to the use of a rights principle, equality, when it has been used to remove rights from Indigenous Māori?
Big thing I think is when we talk of equality, the essential thing is the acknowledgement of difference. If we are to work together and proceed as a people, we must respect how communities differ from one to the other. We must respect the difference that able people have from the disabled, that men have from women, and different cultural groups that exist. So to talk of equality creates a real problem if we so focus on it as to believe that all people are the same when all people are not the same.
Thank you, sir. Thank you for providing your submission with me this morning. We do appreciate your time being with us.
And vice Eddie.
Folks, we're going to move.
Well, that definitely it was a more constructive.
That's different.
Response, Sam.
Sorry?
Oh, I thought the video was still playing in the background.
Oh,
Thing.
okay.
Well, that was very interesting,
Okay.
wasn't it?
Very I'd say constructive, and it's interesting the bits that were brought up, which I think some people miss. I do like Steve Abel's question, though, was about how do you claim about was it giving was it giving people equal rights when you're taking Indigenous people's rights away?
Yeah.
That really put a good part there, because taking someone's rights away isn't giving everyone the equal rights. It's you're taking something that they previously had and like confiscating it.
Right.
Just relax.
Yeah, exactly. And what a lot of people need to realize as well is that there is a difference between equality and equity. Like, if someone gave me $1,000, I'd be extremely happy with that. I need that $1,000. If someone gave, say, Christopher Luxon $1,000, he'd look at it as pocket change and go, "What do I need that for?" That is equality. Giving people what they need to get them onto equal footing with the rest of the population is equity.
And a good example of that was women's suffrage in 1893.
Yes.
Even though I wouldn't call it full equal suffrage, because of the fact that, women had the right to stand for mayors and stand to become councillors. They still did not have the right to stand to become an MP until the 1920s. But they had the right to vote for the MPs, ironically. Yeah. Now, there's another one that you've highlighted was it Te Kanawa Wilson's speech, and it will need translating, which is probably where Jordon's going to come in.
Yes, we're going to need you for this one, Jordon.
Don't drop out. But it's all right. I've got a Zoom to sit down there and actually get to it, because it's free. It's 3 hours, so I'm going from about 1 hour 30 to 3 hour 30 mark.
Yeah.
Right. So that's just before me, I think.
No. You're in the
after me.
afternoon. It's a different stream.
Yeah, 3.5 hours.
We did the one that was in there that was it Common Grace Aotearoa?
But it was it was before the church, or after the church. Dr. Ganesh Nana had his kōrero.
Oh, right, yes.
325, which...
Yeah, but one of the reasons I wanted to cover Te Kāwana's submission is not only because it is completely in te reo, but also he is one of only 2 rangatahi voices that has spoken as an oral submission. So I think that's really important to listen to.
And actually, there's a big audio gap as well.
If those in the gallery would like to hear the translation.
Kia ora mai tātou.
Kia ora te karawa, over to you.
Amihi. Tuatai, kei te tia mana o te komiti whakahaere tēnā koe, e te iwi, e ngā mima pāre mata, wau te aroa, tēnā koutou. Tēnā koutou, i tā koutou whakai mai, kia tū ai au, i mua i te aroaro, o te tini, me te mano, ki te whera i aku whakaaro, o tēnei pire nei, ara, tāku i tēnei rangi nei, e whakahe. No reira, nōku te maringa nui, mihi nui ana. Ka tira, te kanawa nuku hau Wilson tōku ingoa, te kaumaono aku pakeke, he uri au no te kāhui maunga, no Ngāti Porou, no Ngāti Maniapoto, whaingaroa moana, anō hoki. Rua pēr ngā kaupapa toa, te katoa o te motu, te pūtaketanga.
Okay, no, I've got that up as high as
Te
possible.
mana motu hake, tēnā I te mana tīreni. Te tuarua, tēnei mea te iwitanga. He oi, I mua I taku aro, ki ngā kaupapa.
Okay, his whakaaro, he's only 16 years old. He's from Ngāti Porou, from East Coast, from Maniapoto, Taumaranui, Waikato. He's saying, he momo te taima, this is a waste of time.
Ki te tūraki, tāna e hia ai, tika mai, he mai.
Yeah, he's basically saying this is a waste of our time, waste of our money, waste of our resources, waste of our own kōrero. Yeah. He's calling them a sandwich or a burger.
Ako ngā raiti, ka puta I te tiriti o Waitangi, he raiti āhapu, āiwi. E hara I te raiti a tangata ko tahi. Pēnei, I ngā
Basically, the hapu have the rights and the tikanga and the kawa to make their own decisions
te kaupapa tuatahi, o taku kauwhau, te rangi ne.
for their hapu, for their family, for their iwi. Because we weren't iwi, we were never iwi, we were always hapu. And the Declaration of Independence, we were all hapu of nations, not just one nation, Aotearoa. We were nations of Tūhui, we were nations of Taranaki, we were nations of Ngaitahu, we were nations, we were only our own nations, we had our own rangatiratanga, we had our own rangatira for our own areas, so we had princes and kings and queens in every area, and then we had to then we'd set up the Te Kaumarua. He's only 16 years old. What an intelligent young boy. He was raised in Kirikiriroa, Hamilton. Rākau Mangamanga. He was raised there.
No reira, anei, e noho nei, ana, e noho nā, e tahi o ngā hua o enei kaupapa. Me kore ake ko te whakaungia o te tino rangatiratanga o ngā hapu e te tiriti o Waitangi, wa kore te kōhanga reo, wa kore ngā kura Māori, wa kore rawa au e tūnei,
Where's the kōhanga reo? Kōrero.
Kia tū ai au hei New Zealander, tēnā I tētahi uri no ngā iwi me ngā hapu. No reira, nā te mana motu hake,
he's basically saying New Zealanders have got the say. Right now, we are the tangata whenua, we are the kai kōrero for the kōhanga reo movement.
Ngā kaupapa I ora ai a hau te taha mo tēnei wā. Kia anga taku haere ki ngā kōrero o te tino rangatiratanga me te mana motu hake I ngā whakatau ngā tiriti. Puta noa te motu whānui.
So tino rangatiratanga is our most prominent, mana motu hake, all of those tangas.
He kaupapa pai e nei, hei painga mo ngā iwi katoa. Karongo te katoa o te motu I ngā hua. Pēnei I te tau.
Basically saying that if Māori are well, everyone is well. What King Tuheitia spoke about, what everyone else has said under every doctorate or whatever, whoever. Basically, our priorities are tino rangatiratanga, mana motu hake, toi tu te tiriti,
Whakatauria ngā take tiriti. Kia whai hua
kia
i ngā
mau,
muri.
kia mau,
Nā wai rā, ka whai
meaning
hua
as in
hoki
hold
te
fast,
hapori me ngā
hold
kamupene.
strong, hold
Ara,
staunch.
ko te awa tērā, the base,
Yeah.
e tū ana ki te rapa, ko ngā ho tērā, hei te taone, korua kura, tai atu, kia tāmaki ma kaurau, horapa atu ki te motu, no reira, i hangaia e rātou, tō rātou ake whare, e tū tangata ngāna taua whare i tēnei wā tonga. Sua toru, ko ngā rahi o tōku pāpa, ko te awa o whanganu. He tauira mo te ao katoa.
He's Wanganui. He's a descendant of
Te reo
Wanganui.
ake o te awa. He oi, ko ia hei tūrama
Aye.
o ngā awa katoa, puta noa i te
On his
motu,
dad's
nei
side.
te ao whānui tonu. Maraira, he aha te he o ēnei hua pai, e rongo ai a Aotearoa whānui. Ara, he painga mo te ohanga, he painga hoki mo te tai ao, he painga mo te tangata, he painga mo New Zealand. Katoa, nā te tiriti. Nā te hia o te
There's this thing saying our environment, everything that we have as a Māori people involves everything.
Mana, ko te tika me te pono, hei roto i te he. Ka tira,
Yeah.
ko nei kupu, e tuku nāna i runga i te ngākau aki. Mo tāku ki a koutou, turaki nā tēnei pire, hei oranga mo te Māori o tira, hei oranga mo te katoa o Aotearoa. Kia tiki nā atu ai, tau kōrero, hei taku
Yep.
tuakana,
Hard out.
e mea ana, kaura tonu mātou, ake, Aotearoa, mati ke mai. Me nā he pātai a koutou, tukuna mai, reo Pākehā mai, reo Māori mai ngari kangana, roto i te reo Māori.
Kia ora te kanawa, thank you for your submission. We've got a little bit of time left. Any questions for te kanawa?
Hana.
Hana.
Tēnā rā koe, te komi te whakahaere e James, waihoki tēnā rā koe. E te kanawa, e mihi kaiwana ki a koe me tō koroheke i ngā rangitata nei. Kua pāhi ki au i tō kōrero nei te ngā take toru i
She's just doing a mihi to him first.
i tēnei rangi. Ko tāku pātai, mōhio kaiwana tāua TV Māori ngā pēhitanga nui ka whai, mena ka haere tonu tēnei pire. Engari, kia whakaaro, he hanga pēhitanga nui kia tāuatahi te hunga rangatahi, waihoki ngā whakarea ngā haere ake nei.
Ko tā te pire nei, he ngana ki te turaki.
What does the rangatai have to do with the tino rangatiratanga of
He ara tērā, e pai ai
mana
te mokona hati au te reo
motuhaki
rangatahi.
with the Treaty of Waitangi? They have everything to do with it because it's everything about them.
He take tāmi, he take turaki, i te
It's
mana
all
o te
about
rangatahi,
generational
i te mana o ngā Māori katoa.
information and
Kia ora te kanawa,
transformation.
thank you for your time with the committee this morning. We appreciate your submission and thank you for giving.
Thank you for translating there, Jordon. I
don't know if I translated all of it, but I got the gist of it because it was hard to hear.
and,
But
and once you put the gist of it, that made sense to me. Like, you know, because I picked up some of it, but I don't pick up all of it because my knowledge in it, I can't understand it.
Hatsuru was very fast.
Yes.
Hatsuru was very fast because he's been taught from day dot.
Yeah. So it's
from the day he was born to until now.
Yeah, like to me, the biggest thing I tend to pick up when I hear the translations tend to be either the date, numbers. That's one thing I pick up a lot in translations from today English.
That's great.
I remember I was going to I think I was at the swearing in of the Wellington City Councillors, and I said to the person to me, he goes, how you going? I said, I'm getting 1 in 4 words. He goes, well, you're doing better than me. What's there? Go, the date. And he just cracked up laughing, going like, oh, yes, okay, you get 1 in 4 words, but that's how frequently the date's been said. Yeah. No, it's brilliant to have someone who's 16 years old sitting down there and doing a submission.
Out of it.
Yeah.
And it proves that your youth are interested.
Absolutely.
In what's
See,
going
they
on
need
in
to
our
change
country.
the law and bring need 16-year-olds.
Sorry, what are you saying, Jordon?
To vote in the next election.
Well, it proves one. I mean,
allowed a 16-year-old to have a kōrero because
there is nothing in the
in the next
legislation that actually
referendum or in the
states.
next government, I think we're
So
going to eat things.
Yeah.
Because why?
Legislatively,
Because they're learning about government and how it works and at school, and then they leave school and and when they become adults, they oh yeah right oh I remember that, but at 16 years old, it's fresh in their mind.
For submissions, there is no age limit on who can actually put in can speak at a submission. There is something that's in there, just like there is no age limit of who can sit in the witness box of a courtroom, who can, there are, it's just the voting part has an age limit. The ability to be enrolled has an age limit. Ages to be tried at, there's an age limit, but there are some things which don't, and putting in submissions does not have an age limit tied to it. Now, there's one on here which Stacey highlighted.
Well, that's interesting. So why would they have a non-tied part to age and have a tied bit to the voting of you have to be 18?
Well,
that don't make sense.
That's been something that's been around. And remember, the original voting age in New Zealand was 21, not 18. It's only been 18.
It was 21?
Yes.
Oh, no. I thought it was... Oh, wasn't it 20? Oh, no, it was 18 and then went to 21 and then back down to something.
It started off as 21. So the original age of voting in New Zealand was you had to be 21, male, and own land in an individual title capacity. And then that was the reason for the introduction of the Māori seats, was because Māori collectively owned land, which wasn't able to work, which I think they screwed up with. I think they screwed up Māori seats because there was no proportional representation until 1996.
Right so. And see, like right now, cousin Debbie Ngāti Wapeka in the Māori Party, she has to contend with 65 Pākehā seats all along her takiwa from Wellington to Te Awamutu. She's the only one, and in Te Ao Māori we work with tāne me te wahine, and they say that she has Rawiri Waititi, right? Yes, she does, but she does not have anyone on Te Taihauru. So I want to put it forward to the Crown that we need 2 Māori representatives on every party, Māori and female. Why? Because the status quo right from the start has been screwed up. And I'm going to say, let's say fucked up, because it truly has. It has always served the purpose for the Pākehā, for the colonial people that have raped, pillaged my people, have been thieves themselves, come over here and reform themselves and ladies and whatever else. But in all, they were thieves, they were murderers, they were pirates who conquered land. Let's get, because the first Pākehās that came here first were the missionaries, and the missionaries wrote to other missionaries and popes and everything else, and stated that Māori people here in New Zealand were the most welcomingest people ever. Their children, their fatherly schools and motherly schools were so enhanced that it didn't matter whether you were gay or straight or whatever, as long as you procreated children and looked after them in the community, not just your children, but the community's children. So your hapu, your iwi, but we weren't an iwi. We were only hapu and whānau.
Yep. Okay, let's move on to the
and 550 something people that actually signed the Declaration of Independence. But remember also, there was more that signed the English version because the Māori version was scrapped out because they couldn't find it. So they started using the English version, getting rangatira to sign the English version. The original Te Treaty of Waitangi or the Declaration of Independence, it did not match. The kōrero that was on the English version was way less than what was on the Māori version, and on the Māori version, tino rangatiratanga does not give sovereignty to this government. It gives us.
We've got another submission to move on to.
As a Māori people, as tangata whenua, the reason that they came here is because we were doing better than them. That's the reason why they came into
Jordon,
Parihaka in 1881.
Jordon, we need to move on.
Yep, sweet. Okay, haere tone. Sorry, I'm getting my ihi and wihi. That's what we say when we
Tēnā koe to the chair. Tēnā koutou to the
not
select
overwhelmed,
committee.
but like
My name
passionate.
is Stacey Fong with Mings.
Yeah. Okay, let's kick off with the submission because it's really good.
Zufu,
Yep.
and we are here
I like
representing
you too,
Asians
Chrissy.
supporting Tino Rangatiratanga. We are a national organisation of tau iwi from diverse backgrounds who support the restoration of Māori Indigenous sovereignty. Many of our communities have migrated or been displaced because of colonialism and imperialism in our homelands and beyond. As tau iwi, we have been afforded the opportunity and privilege to live in Aotearoa by virtue of Te Treaty of Waitangi. We start our submission on the inalienable fact that Māori have never ceded sovereignty and ground our submission in the full text of Te Treaty o Waitangi. We oppose this bill because it desecrates Te Treaty, a sacred and generous agreement that allows immigration to these lands under the clear condition of protection and respect for tino rangatiratanga. This bill is dishonourable in its distortion of the language of equality to erase Indigenous rights and further violates Te Treaty. This bill, although not passed, is already causing division and emboldening racial discrimination towards Māori, including in our communities, and it will continue to do so if not stopped. This bill distracts from the urgent issues of the climate crisis and resurgence of fascism across the world, stemming from the centuries of colonial and racial capitalism. Furthermore, the Crown has not consulted or negotiated with all parties to Te Tiriti around this bill and cannot unilaterally redefine the meaning of the principles of the Treaty of Waitangi.
Now, hold on, sorry. This is what happens.
Meanwhile, this bill denies tino rangatiratanga for Māori in the first two proposed principles in order to cement Crown sovereignty and limit the scope of Māori political power. Professor Margaret Mutu defines tino rangatiratanga as a paramount authority, and what was granted to the Crown was kawanatanga, a delegated authority to have a governor to manage their own people and those to come. The Crown was never granted power to govern over Māori, who long have had their own political structures and independent nationhood. Proposed principles do not reflect the Articles of Te Tiriti. We see the underlying agenda of this bill is far from equality, but the removal of barriers for corporate interests and extractive industries to further exploit Māori land. We find the prioritising of short-term profit in the midst of urgent climate catastrophes a devastating betrayal to rangatahi and future generations who will face even worse environmental crises.
We also want to briefly speak to the history of the Crown trying to put a wedge between Asian and Māori peoples. For example, this includes the anti-miscegenation efforts to prevent interrelationships between Māori and Chinese and the unofficial white New Zealand policies restricting Asian immigration. Our solidarities are threatening to the existing colonial order. We see the continuation of these divisive strategies in the ways that multiculturalism is used to recruit Asians into a sinister anti-Māori agenda. The party has been spreading treaty disinformation in Asian communities, such as in Chinese New Year festivals and gurdwaras, and feigns care for migrant communities to pit us against Māori. Liberal multiculturalism undermines tino rangatiratanga and subsumes Māori as just another ethnic minority group amongst others, which conveniently erases indigeneity and denies tapu and iwi rightful political power. Indigeneity is not wholly about race. It is also a deep and unseverable relationship to land that colonisation has sought to destroy. This is an important distinction that our communities understand.
But despite the divide and rule tactics, we have long begun forming direct relationships where there are many beautiful stories and histories of mutual aid and care. Matua Mona Jackson has shared some of these stories with us, including some from his own whānau. Our own relationships with tangata whenua are also testament to these solidarities, and our experience at the hikoi shows glimpses into what Aotearoa could be on a larger scale, showing the power of refusing to be divided by white supremacy. Throughout the hikoi, we were met with warmth and manaakitanga and hosted by Māori friends around the country. People of Māori and Asian whakapapa came up to us and shared their stories. They reminded us that our communities are not separate, but interdependent, and that our liberation is therefore interlinked.
And counter to the divisive intentions of the bill, we have come together. When we have offered accurate and translated information to our communities, our peoples have all expressed desires to uphold their responsibilities in honouring Te Tiriti o Waitangi. When we organised collaborative submission parties across the country, both in person and online, we saw full house attendance from migrant and refugee communities. We have seen our communities take the initiative to provide informative and engaging translations about Te Tiriti o Waitangi in a growing number of languages. Our belonging in Aotearoa is contingent on honouring Te Tiriti. All peoples in Aotearoa have responsibilities to uphold tino rangatiratanga, to live in interdependence, where we can be strong in who we are. We have been strengthening cross-community solidarity against colonialism and against racism so that we can move forward together to a just future that is honourable and good for all.
This bill must be stopped. We call on the government to comprehensively reject this bill and abandon other bills that seek to undermine Te Tiriti and Māori rights. Instead, we call on the government to focus on implementing the visions for constitutional transformation in the Mataki Mai Aotearoa report, which will actually bring about meaningful equality and justice for all of us. Toi tū he whakaputanga, toi tū Te Tiriti.
Thank you, Kirsty. Members, any questions?
Yes.
Mari meno kapakingi.
Thank you. Tēnā koe, Kirsty, tēnā koutou katoa. You, somewhere in your discussion, which links directly to your submission, you talk about tino rangatiratanga is not just a Māori take. It is a shared commitment to justice for all. And hearing the sentiment and the directness in your discussion this morning, kānui te mihi kia koutou, it is so helpful for the committee to hear you and see you. I'd like if you could just, to help the committee even more, in the statement, it is a shared commitment to justice for all. Can you just talk a little bit more so the committee can get a further layer of what that statement means for you?
Absolutely. Do you want to go? Okay. Well, we see that racism in this country stems from the history of colonial racism and the treatment of Māori. And all other racisms as migrants that we experience are connected to that foundational violence of colonialism. If we do not address that foundational violence, there can be no racial justice for any of us.
Thank you. Members, any more questions? There appear to be none. Thank you, Kirsty. Thank you for...
I like Charlene's comment.
Yeah, absolutely. Yeah, that's why I threw it up on screen. Yeah, I absolutely agree. It's not just a Māori, I've lost the word, I'm just going to say problem of your manaakitanga and tino rangatiratanga and kawanatanga. It is something that the entire nation needs to embrace and work towards. We are divided as a nation until we can do this.
Yeah. Anything you want to add, Jordon?
I want to hear your whakaaro first because my own family married into and they've done really well in the what do you call it, marakai,
you make it sound like
gardens and Waitara and
you're from Waitara, your roots are from Waitara. Oh God, that is very
my
small
great grandmother
world.
was born in Purangi on the Waitara River. But we call it the Awaroa River out there in Ngāti Maru. But, yeah, I lived in Waitara for quite some time. And the Ki Sioux whānau, they whakapapa to me on the Whakaruru line. And they were migrants that came here that married into my own wakapapa. And their father did very well as a market farmer. But he didn't just do it for himself. He did it for his community. He did it for his whānau, because even though he wasn't Māori, he became a Māori. because he married a Maori, and then he became a part of our whānau.
Mm.
And they
Yeah,
had
no, I know one
four or
of
five
the
children, I think.
Yeah. I know the Tartaners in Levin are a mixed Māori Chinese family, and it's literally just the way that
And
happened.
they're also the grey whānau in Otaki.
Mm. Yeah.
And
Let's
what's his
kick
name?
off
Sue?
with the last name Sue. I know is a Levin Market Gardener last name. I do actually know that because I've got a stall at Newtown Market. Yeah. Okay. Let's kick off with Marilyn Waring.
Yeah, we are now on to Monday afternoon's videos.
There I am, right at the back.
We're going to go to submission now from
I'm right
Marilyn
at the
Waring.
back.
Marilyn's going to join us online.
Tēnā koutou katoa. You
Good,
can hear-
Marilyn. We can. If you can turn your video on, if that's possible, we'd appreciate that. Thank you and welcome to the committee. You're relatively familiar with how this process works, so I'll hand straight over to you for your 10-minute submission.
Thank you, Mr. Chairman. Tēnā koutou katoa. I'm going to take just a couple of moments to expand on the opening comments in my submission on equality and rights. So in the general policy statement, we're advised that the bill wishes to create a conception of each person's rights within our constitutional arrangements. Well, fundamental to our undergraduate studies in our university is to learn that different cultures have different concepts of ideas. So I don't really know, I've no idea what create a conception for all people might mean, but it's clear in Clause 6, Principle 3 of the bill, that formal equality means everybody gets treated according to the values of the dominant group in society, because that's always what formal equality has meant and does mean. But the meaning of equality is so highly contested that there's no universal agreement as to what it means. And this bill is based on the old approach that pretends that everybody's born equal and that people can have the same treatment regardless of differences, and that's equality. Well, you might meet this approach in a history of ideas course, in an undergraduate philosophy course. That's where you find Aristotle and Plato. But thankfully, we've moved on from the formal equality conceit. Then there's this issue of concepts. Concepts are hugely varied in their meaning and interpretation, and they're subject to paradigm shifts. I'm kind of had my breath taken away this morning and this afternoon listening to people, as if codifying something into law means that time stands still. One of the reasons we have the judiciary is to take account of the fact that Parliament never keeps up, and Parliament especially never keeps up when it's about people's rights. And the Minister this morning reiterated that the bill is his belief. Well, beliefs and concepts are what we call ontological and epistemological. Like, how do we know what we know? So they're constantly in motion. And what one man's ontology and epistemology mean to him is not a basis for constitutional change. In Clause 4 of the bill, there's no definition of the key terms equality and rights. So the bill appears to take for granted that equality and rights is the same old we are all born equal rubbish. So there are two key points to be made. Key features of the treaty are the rights of Hapu and Iwi Māori, that is collective rights, referred to in Principle 2, but in Principle 3 is entirely singular. There is no space for class actions or collective rights. And the bill reiterates this singularity. Everyone is entitled to the equal protection, equal benefit of the law, equal enjoyment for individuals of the same fundamental rights. Well, protections and benefits and enjoyments are static words on a page. If you're interested in equality and rights, the foci are outcomes and results. So what should equal protection, benefit, enjoyment mean? Well, whatever Hobson's choice say, fortunately, Western democracies have embraced and recognised the practice of substantive equality. And substantive equality is not a concept. It's an analytical framework. Now, where a person or peoples have been subject to socially constructed, historic, systemic and systematic, accumulative disadvantage, Equality cannot be achieved through equal treatment, and there can be no question but that iwi and hapu in Aotearoa have been subject to socially constructed, historic, systemic, and accumulative disadvantage. You address this through substantive equality, through equality of outcomes and equality of results. And for an earlier person this morning who wanted to know, will substantive equality work? Well, it aims to change and transform discriminatory practices. There are plenty of examples of abuse in the European Union, the European Court of Justice, the Supreme Court of Canada, acting on their Bill of Rights, the South African Constitutional Court. Substantive equality is about redressing disadvantage. It's about addressing stigma, stereotyping, prejudice. It's about enhancing voice and participation, and about accommodating difference and achieving structural change. Substantive equality aims to change and transform systemic discriminatory practices. Equality is never achieved through equal treatment. Thank you, Mr. Chairman, for the opportunity to expand on my submission. There may be questions.
Thank you, Marilyn. We've got two questions to start with, first from Duncan Webb and then Ginny Anderson.
Kia ora, Professor Waring. Can I just say how much I enjoyed reading your submission? And you draw a direct line from your own family story, from the Tainui Wars to the present day, and then close by saying if we don't learn from history, we're doomed to repeat it. One of my concerns in this discussion we're having is that people are looking at things in a very short time span. They think of, the 1980s and beyond. And I guess I'm just inviting you to talk to that part of your submission and how where we are today is affected by, where your family was 150 years ago.
Yeah, well, one set of my great-grandparents was married by Reverend Ashby, who was set up the mission station at Kotatehi, where Te Wherewhero's pa was. So in 4 generations of my family have farmed and owned lands in Taupiri and Komakarau, and then other parts of the Waikato. But the principal family farms were established because Waikato Tainui had to desert their lands and run south of the Punui River. And I've never forgotten that. And I had a message from my brother the other day, just saying, go sis. And he was saying, we've watched our families bear the fruits of decades of subsidies in farming, and then the decades of profit from there not being a property speculation tax. And we watch how those generations have talked about that, and they never want to remember. They never want to remember. That many people were murdered, exploited, disenfranchised, so that those families could be successful.
Thank you, Dr. Webb. Dr. Waring will go. Ginny Anderson.
Thank you very much for submitting, and thank you again for your submission. We've heard today a lot about equality and the importance of equality and everyone having equal rights. I'm interested on your view of what happens when that version of equality negates someone's identity. What happens to New Zealand when that plays out?
Well, I think we go backwards in terms of, the decades of some forms of progress that have been made in my lifetime. While I think one of the very best examples of the reasons for substantive equality are te iwi Māori, they're obviously the same for women, for those with disabilities, for children who still substantially don't have a voice. If it wasn't for substantive equality, there are a whole range of legislation in New Zealand that simply would not have proceeded. I know it's only sort of one class of people, but matrimonial property, for example, the kinds of different health policies that must be made for women, whether it's around pregnancy, maternity, menstruation, a lifetime of submitting to superannuation schemes to then find you're still tens of thousands of dollars behind men because there was pay inequities. So we're surrounded by substantive equality and the challenges of it all the time. For those who are...
Sorry, Dr. Waring, I'm very sorry to interrupt, but that is the time for us allocated today. So,
what do you think of Marilyn's submission? She doesn't feel like she was in the National Party.
No.
It's not.
Yeah, it's.
She feels she's in the green for me. I don't even know if she is in the Greens or not, but if she was, I would vote for her.
Yeah,
she may feeling Mamai for her own family, genocide, Māori, which would be so. My great-great-great-grandfather, Thomas William Conroy, who was joined the constabulary when he was 18, watched his parents get burnt alive in a church in not Canterbury, Cambridge, because a week prior, the New Zealand Constabulary marched on to Rangiriri and Hapu just down from Rangiriri and wiped them out completely. Murdered every single one of them. Raped the children, raped the woman. Yeah, it was horrible. So Putatau Te Whiro sent out some troops out to Cambridge Church on a Sunday. Only 3 people escaped. My great-great-great-grandfather, Thomas William Conroy, was one of them, and he was 17 years old, 18 years old when he became a constabulary member and was marched on to Parihaka in 1881 to do the nasty things. Ended up marrying Waikarenga 4 children. And he got locked up himself. He became a Māori himself. He ended up being a translator for Pākehā and Māori between Taranaki, worst times ever. And John Akerd Love and all of them, they were all best mates back in the day.
Yeah.
Because he could speak, they both could speak fluent Te Reo. It's phenomenal. Our stories in Te Ao Māori have not told by a Pākehā's word of mouth. Our books and everything have not, where it's been told Pākehā whakaaro. Māori, not Turu Māori. There may be Māori that are scholars and everything, but ordinary people have ordinary stories, and they go back long back. You know, we look into some history, family history, and you find that this woman's great-great-great-grandmother was a Pākehā woman, but was raised by Māori because her parents were killed. You know, there's all these little things. Our people weren't murderers, and they manaakira everyone until you screwed them over, really. And if you screwed them over, they would either eat you or they would feed you to the dogs or to the pigs. At Pukerangiora, we used, the Pākehā used to call the Pukerangiora the pig pen. And it was full of humans.
Yeah.
And they would go to the slaughter. All Māori. There's so many different little stories around the country.
Yeah, exactly.
But I mihi
so
to
I
that
found out-
queer.
Absolutely. No,
Sorry,
I
Stacey,
found
go
out
ahead.
just a few years ago. No, you're all good, Jordan. From my mum that, you know, on my maternal side, my whānau didn't even know that we were Māori through my great granny's generation, because she didn't want to admit that we were Māori because she didn't want her whānau and her kids prejudiced by it. You know, so it was only my nana, my mum's mum, started doing genealogy and whakapapa stuff and discovered all of our Māori links. So, you know, my whānau...
And where are you from, Stacey?
Well, my maternal whānau have only known that we're Māori for 2 generations. Like, we are still learning because our our stories were erased basically by our own whānau because they didn't want, which is why we all have Pākehā names, because they didn't want us prejudiced against, and they didn't want us beaten in schools and things like that. And so Jordon's right, there are a lot of stories out there of Māori whānau that have never been told and unfortunately will never be known. But
look in deep south, there's many Māori in the South Island that don't even, and they find their genealogy through the DNA testing, and then they're looking for their whakapapa, and then they're like, oh, we're Māori.
Exactly.
Yes, you are.
Exactly.
Basically, 50% of this country is Māori, because we have every ethnic group in the world. Māoridom does.
Yeah.
I don't know if it's 50%,
but roughly, yeah. My mum's brother, my uncle, has been doing a lot of genealogy work over the years, and I'm pretty sure that he was the one that discovered that we are direct descendants of Te Wainahi of Te Atiawa, who signed Te Tiriti. And so finding things out like that, I'm pretty sure that she'd moved to Wellington from Taranaki at that point.
Right. Because a lot of them left Taranaki, and went back in the 1860s because of the Taranaki land wars at Te Kōhia Pā. That's where Brixton is. That's where the cannon was fired upon Māoridom for the very first time. And then John Love fired back at the government, at the colonial government at the time, because he was a friend of ours. And actually, his first wife was an English woman that couldn't stand him, apparently. And he started escaping and going to see a Maori woman from Waitara.
Yeah.
And he had her on the boat, and eventually he married her, and then that's where all the loves, there's hundreds of them, come from.
Yeah.
Because he married 3 women, I think, or maybe more, I can't remember. But I'm a descendant of him too, and so are the Allisons. There's so many different, the Paratas. There's so many different whānau that are connected to John Love, and he's revered to us in Taranaki as a hero. He's the reason why we're still here. If it wasn't for him, we would be all gone.
Yeah. We'll get on to Jane Kelsey now.
Yeah.
So can I just acknowledge your submission and thank you on behalf of the committee for being with us today. We do appreciate you being here.
Thank you.
Kia ora. Thank you.
So we're now going to invite Professor Jane Kelsey up to the table. Thank you, Jane. Thank you for being with us. I think you two are also familiar with the process, so I will invite you to present your submission.
Oh, we already watched that one.
Kia ora. Thank you. Can I speak to you in 2 capacities? One is someone who spent over 4 decades as a legal academic and researcher on Treaty of Waitangi policy, focusing in particular on areas of treaty principles, which included my PhD thesis, a number of books, and evidence to a significant number of Waitangi Tribunal hearings, including most recently
behind you.
treaty principles.
Oh,
my
no.
second capacity, and this kind of follows from what Marilyn Waring was saying, is as a Pākehā who in Aotearoa believes that we cannot cut ourselves adrift from the foundations on which we and our tupuna were here. And in my case, like Marilyn, my mother's whānau come from a place called Sentry Hill in Taranaki. And I always used to teach my students what Sentry Hill actually was about and for. And so I think those personal stories are very important in us understanding the implications of what this bill tries to do. Secondly, I have also been asked to make a point to the tribunal that there are many, many people, especially many, many Māori, who have put together submissions on this bill, some of whom took flights down to Wellington with sheaths of submissions to get them in here when the website fell over, and who are expecting that their voices will be heard. And so I was asked to bring that before the committee. The committee itself, the bill itself and the explanatory note identify 4 objectives, and I have no particular problem with the objectives. One is greater certainty and clarity. A second is a more robust and widely understood conception of constitutional arrangements. The third is to build consensus around te tiriti and constitutional arrangements to promote greater legitimacy and social cohesion. And fourthly, to promote a national conversation. What I do have a problem with is the provocative way in which that has been proceeded with through this bill that has caused very considerable harm. And I heard that especially during the Waitangi Tribunal hearings and subsequently to that. The proper place for that conversation is in the Constitutional Kaupapa Inquiry that is now underway in the Waitangi Tribunal. And I would invite the Parliament to endorse and the committee to endorse that as the appropriate forum in which to work out how we move forward. I have a different approach from a number of those who have made submissions, and it comes out of my many years of research, which is that I have a problem with the notion of treaty principles themselves. And I remember in 1990 at Waitangi, when Bishop Whakahuipi Virko said to Labour, "We do not need your principles, we have te tiriti." And my own research, especially in my very lengthy PhD thesis, looked at and traced through the construction of the notion of principles of the treaty in the 1980s, and which brought into the light what Ngā Tamatoa in their 1974 submission on the Treaty of Waitangi Bill said. You talk in this bill about treaty principles, but whose principles and who is going to define them? And so the research I did in the 1980s in particular showed how quite cynically the concept of the principles had been constructed. And there was reference earlier to the principles for Crown action on the treaty in 1989. I got leaked a whole series of documents whilst they were being constructed by those who were uncomfortable in doing it because they were basically asked to rewrite Te Treaty o Waitangi through Crown principles. So to me, this Act Bill is a logical extension of those attempts to bypass the realities of what are in Te Treaty o Waitangi and substitutes them with something that the Crown can be comfortable with. And in my submission, I quote, for example, Sir Robin Cook before the Lands case, saying the Treaty of Waitangi can't really pass muster as a document to take seriously today. And then describing his principles in the Lands case as being a subtle constitutional repositioning, which David Longy repeated in 1990 at the Commonwealth Law Conference in Auckland. And so we need to actually put aside this principles as a vehicle through which we have been avoiding having the constitutional conversation around Te Tiriti o Waitangi. Let me just make 2 further points. The issue about the referendum. It was extremely concerning in the Waitangi Tribunal to hear that the officials have been asked in parallel to this process to be working on implementation of a referendum approach on this bill. Now, we hear this bill is not going to proceed, but that doesn't mean a citizens-initiated referendum cannot be instituted and an attempt to have that at the time of the next election. And already the cogs are moving in that direction. That is a major problem. The second is that even if this bill fails, as we've been told it will, the Regulatory Standards Bill, promoted by the same minister in a manner that has been completely antithetical to what are supposedly best practice regulatory approaches, would effectively write Te Tiriti o Waitangi out of the priorities in the lawmaking processes. And so I think you will expect to find there is an equivalent move on that occurs irrespective of what happens with this bill. And the coalition agreement, unlike this, which says taking this bill to select committee, although David Seymour's remit is and passing it, the Regulatory Standards Bill is to be legislated. And so I invite the Select Committee to seriously consider the implications of that for Te Tiriti o Waitangi. Kia ora.
Thank you for this, Kelsey. We've got 2 questions lined up. First from Duncan Webb, then Mariamino Kapkini.
Kia ora, Professor, and thank you very much for that submission and all the work you've done. I'm interested in the discussion you had around, your lack of enthusiasm for principles, full stop. And I guess how we approach what the treaty means today and how we apply it to real world situations needs some tools, right? And I guess the principles might be a useful shorthand for those tools. But I'm interested in your comment and your thoughts on how we actually approach the kind of changing obligations under the treaty today due to changing social and wider circumstances if we don't have principles.
I don't understand why you need to have principles. You have very clear concepts from my understanding of Te Treaty of Waitangi, and I've had the privilege of being tutored by people like Rob Cooper from Ngāti Hine in what that actually means. And if we look at the core value structures that underpin that, if we look at manaakitanga, if we look at whanaungatanga, if we look at kaitiakitanga, we can actually see in practice how that plays out. And so I don't see why we need principles to get us to that point.
Thank you, Jane. We'll finish with Marimino.
Thank you, Mr. So why do you think? So, because I can hear all your expertise mentioning Rob, that's a neat thing straight away. So what do you think is behind this noise and this distraction, if I can say that?
I think it is actually a political stunt that is about political opportunism and the fact that there is this disingenuous approach of the same minister to regulatory responsibility and to treaty principles suggests that he himself doesn't actually have principles. And we have in the academic other hat I wear about principles-based regulation, we say it only works if those who are involved in regulation have principles.
Thank you, folks. That's the time we've got for this afternoon. So can I just acknowledge your submission today, Professor, and thank you for spending the time.
More receipts. I like the point about what Jane mentioned about the conflict of interest aspect with two particular pieces of legislation that conflict with each other, having the same minister's name to it in charge.
Yeah. Taxpayer-funded advertising for the ACT Party? Yeah, absolutely, Laura. Absolutely.
Yeah. So what do you think about Jordan? Jordan, what do you think about Jane's submission?
I don't know what to say, actually. It's a bit of a
because I mean you've already been there once watching it.
Yeah. I still don't understand it. He's used words that we don't use in a normal context. That's why I like Dr. Ganesh Nana's submission, because he used political tactics, but he also used everyday speech. Like, you guys are children in the room. Act like adults, not children. Yeah. He was down to earth and made it, he normalized his submission, which made us listen more intensively, more than the ones that were the academics. And he's an academic, and he got questioned by I've forgotten her name. Said something stupid, and the chair said, "I think we should just throw that out." Yeah. There was a dumb question.
That was.
There was in Ganesh Nana's submission in the question. So it was only he was on the right-hand side. And one of I think he's in the Greens or he's in New Zealand. Oh, I can't remember. But he spoke and said that was a stupid question. What was the point in that? Basically, what we got to realize is we got to look at ourselves as. So I'm mana whenua. I was born here. I am Maori, and Say, Sam, were you born in New Zealand?
Yes. The hospital you're standing in at the moment. 6
Right.
generations.
Well, I'm not standing, bro. I'm sitting.
I think you get what I mean.
Yeah. Yes, I understand.
I mean, put it this way, I'm not eligible for any foreign citizenships by descent because the generations on both sides of my family date back to great-grandparents born in New Zealand. And I mean, this is different areas. Like, I know that my great-grandfather, grandma's father, basically had a very big post-World War II affiliation with Gisborne. And I mean, it is you know how my grandparents, they were Pākehā people, but they educated in Māori areas, and they absolutely loved it because that was what was it. It's really weird because I've got this two-spoke side of the family. I've got my father's side that's been very supportive of it and all that sort of thing. Then I've got my mother's side that tend to sit there and always go about the negative aspects of it. It's a real big juggling act of what happens when you have the two different extremes in the family on one side or the other. And it's, yeah, I mean, and like, put it this way.
So let's put it this way, you're tangata whenua. Put it this way, you're tangata whenua. And me and Stacey are mana whenua.
Yeah. And my mum's side's the side that has the 6th generation part that I know is guaranteed. I'm not exactly how sure on Dad's side whether it's 4, 5, or 6.
Right.
Yeah.
Doesn't matter, you were born here. So our old people would have seen you as mana whenua, as tangata whenua, because you were born of this land.
Yeah.
Mana tangata whenua means born of this land. Or of this land.
Yeah.
What land? Aotearoa, New Zealand.
Yeah.
New Tireni, if you want to put it that way.
You
know, our tauiwi that come over on a boat or on a plane, they're of not this land, so they are tauiwi.
Can we get to Ganesha's speech?
Yes, please. And then you get to mine, which I never did.
Finished. You to start the presentation.
Yeah, clear. Here's mine.
Tēnā koutou katoa. Tēnā koutou te ina nahi te ina ia nei me te apopo. Ko tēnā taku mihi nā tangata whenua o te ruhi nei. I ngā iwi, i ngā mana, i ngā reo, i rau rangatira mā. Ko Ganesh Ahirao tōku ingoa. I'm a first-generation New Zealander born in Aotearoa to parents who immigrated here as young newlyweds from India many decades ago. I am proudly tangata Treaty. I thank the committee for the opportunity to be heard, and I think it's appropriate I congratulate the chair on his recent promotion. I also wish to acknowledge and mihi to the many tens and indeed hundreds of thousands who will not get such an opportunity to be heard here. I feel privileged in this opportunity and feel their weight on my shoulders, but also their wairoa in support of and lifting me in this kaupapa. In addition to my written submission, I wish to emphasise that this bill is not and should not be treated by this committee as any ordinary bill. It requires more than standard processing. Your task is so much more than that. This thoroughly repulsive bill is yet another disingenuous act of total disregard and disrespect for the status and mana of Te Treaty of Waitangi. And this has caused considerable hurt and harm to Māori. It has magnified, emboldened, normalised and legitimised racist thinking, actions, attitudes and understandings that have hurt and harmed all in Aotearoa, tangata Treaty and tangata whenua. I acknowledge that several leaders have said this bill will not proceed beyond this committee stage. That may be so, but that is wholly and totally insufficient. The hurt and harm has already occurred and is continuing to occur. That hurt and harm and disregard and disrespect must be acknowledged, recognised and corrected. As listed in my submission, there must be a formal apology from this House that this repulsive bill ever got introduced in the first place. And there must be concerted and genuine efforts to repair the bridge between Māori and the Crown. While there may be leaders in this room who are comfortable with the bill just being voted down, I am waiting for the adults in the room to stand up and take responsibility. Sadly, I find myself asking as asking if there are actually any adults in the room or in the house. I strongly urge this committee to see themselves as and act as the adults in the room. Nō reira, tēnā koutou, tēnā koutou. Kia ora koutou katoa.
Thank you, Dr. Nana. Plenty of time for questions. I'll open that up to members for any questions. We'll start with Tangi.
Thank you, Mr. Chair. Thank you for your submission. I was interested in your contribution there that the committee should adopt an approach that is more than the standard processing of a bill. Given that there is a huge number of submissions, and as you yourself pointed out, the inability for the committee to hear from everyone, how do you suggest the committee approaches that? Separate to the apology that you called for from the House for the introduction of the bill, but in terms of the standard processing, what sort of advice or suggestion would you give for this committee in terms of approaching it in that way?
Well, I think firstly that recognition that this bill, as other submitters have made the point, transgresses a whole lot of constitutional matters and foundational matters for this country that I am not at all expert in, but at least at the very least recognise that difference between sovereignty and governance. And if we're serious about constitutional matters and constitutional review, recognise that this House is long behind what has already been started within Māori. If we talk about Mātiki Mai and other processes, Māori have been talking about these things for a lot longer than this current parliament or indeed previous parliaments. And let's have that conversation from a genuine perspective of partnership, as was part of the treaty, and let's have that engagement in a genuine manner. And that's part of adults in the room recognising their own weaknesses, recognising their own status, and recognising their own positions of power.
Thank you. Mai mino kapki.
Thank you. Panis tēnā koe, nau mai aere mai ki tēnei tōwhare. You talked about the emboldened, this whole Seymour bill. It's emboldened this, the behaviour, the worst things. And I'm interested in your communities. What have you witnessed? What have you seen? What have you heard? What have you felt in that regard?
Well, I don't want to give them the standing that they don't deserve, but you just need to, and I wouldn't because I've deleted most of it, but you just need to see the inbox messages on my emails alongside many others that I communicate with. You see it in social media and indeed in other media where the disinformation and or misinformation about the understandings of Te Treaty are being put forward as the balanced view. There's one side and there's another side. We have made as a nation significant progress in my lifetime about understanding of Te Treaty, recognising the background that I put out in my written submission, starting from literally zero when I was at primary school and through high school. That progress is being harmed and set back undoubtedly by the information that's out there that the treaty was in effect a nullity and you don't have to recognise it because Parliament is sovereign and we're allowed to make whatever legal decisions we like and those sorts of things. It's just not an appropriate or conducive manner to have a grown-up conversation about these important matters if we're talking about Aotearoa in the 21st century.
We'll go Rima and then Glenn.
Doctor, thank you for highlighting how young I look. So Doctor, so what's your PhD in?
Economics.
Economics, okay. So while you worked in 2021, we went into one of our worst recessions in history. But thank you for your comments.
Glenn,
am I allowed?
No.
There's no need to respond, I don't think. Thank you. And in your opening submission, you talked obviously about your te tiriti is the reason your parents were able to come here. And in your written submission, quote, you say, migrants who have come to this country for many decades are the very embodiment of tangata te tiriti. Can you just unpack that a little bit more for us, please?
Well, right from the very beginning, we've got to understand, we'll read the treaty and read indeed the preamble to treaty, very much founded on that immigration discussion argument that fundamental were Māori going to allow the colonisers to come in and settle this place. And so from there, that really does enable, that allows, permits my predecessors, my parents and others to come here and settle and indeed enable them to continue to be here. We are here because our tupuna, our leaders, the Crown and Māori signed the treaty. And that is what enables this nation to grow and develop as a Pacific nation of many people, not just a nation of Māori, not just a nation of English people, a nation of many peoples based in the South Pacific. And it's from there that we need to look forward. How do we build on the strengths of all of our people coming together?
Final question from Timothy.
Hey, kia ora. Just on the suggestion that you made around the formal apology to Māori, which I think is a good suggestion, and it's, I think, the first kind of suggestion like that today. But I mean, this Crown apologises for all sorts of stuff and continues on with the same BS all the time. So, like, what more can we do that would actually show that the Crown was actually committed to being an honourable partner to Te Tiriti rather than trampling on it all the time?
Well, I go to my other points in the recommendations, and yes, I acknowledge Crown have apologised to Māori for lots of things. Key thing is genuine apology, which is backed up by a package of things around, in particular, I point out the initial steps is very much of the House concerns to Treaty of Waitangi and He Whakaputanga as founding documents of Aotearoa, and acknowledges that Māori never ceded sovereignty. And that has a point that has been made and found by many legal scholars, and indeed backed up by Te Tiriti Waitangi, the Waitangi Tribunal in its finding in whenever it was, and I'm sure you'll be aware of that. Those are two concrete matters that would at least embed this House recognises its position rather than it being all-powerful, but its position as a partner to Māori.
Thank you, Dr. Nara. Thank you for your time this afternoon. We appreciate you being last week's submission.
Now, I do want to make a point, and I agree with what the comments that came from, was it Charlene here? What Rima, was it Nakul has said, like just trying to take a cheap shot jab about the 2021 COVID lockdowns, I think is an absolute misuse of select committee time.
Yeah.
But that just that just shows the type of unprofessionalism she is. I mean, these are things that have come in there in our stakeholders chat for It's in the Ballot. One of our members lives in her electorate and she has a track record of blocking people that
disagree with
call her out for her actions.
Yeah, that's right.
Yeah, it's so that's something I have to sit there and call out here. That I think on that occasion she got that one wrong because she may not agree with his particular economic philosophy, which is it called being kind, caring, and helping people.
Yeah.
You know, and it's about a leg up, not what do you call it? Pull the rug underneath the person. Now let's get to some more and I do like Tamatha was bang smack on the money. It does feel very odd me saying that. Oh, and Jordan's still on. Oh no, he's been unmuted.
No, I think he's muted himself now.
Oh.
I'm off. Give it up.
There it is.
Yeah.
I don't know. I don't know what party she's in.
It's
but she needs to go back to work.
National.
She's what? National. Well, she needs to go back to school.
Recent immigrant to New Zealand.
Well, she needs to go.
Put it this way: she's a recent immigrant.
And learn the print.
Yeah.
Well, then she should know the history of. She should know the history of Māoridom, because to get a seat here through the becoming a citizen, you have to go through all these things. Now, this is one thing I hate. My grandparents have lived here for years and years and years. They were born here. They're 90 years old. They have no clue about Māoridom at all. They didn't know what a marae was or anything like that. So my dad's parents, they've been on many marae, but they don't know protocol or anything until I started showing them.
Yeah.
Our people get this. Every single immigrant that comes into this country gets to be able to go to the marae, go to a pōhiri, go see a kaumātua, and all of these things. Why the hell don't New Zealanders get that chance too?
And I can also confirm for Rima, she, of all the immigrant MPs in Parliament, she has only been here since 2012. She is an Australian citizen by birth, and she's only moved over here because of the fact she's married a Kiwi.
Wow.
So, and like people hit out at Ricardo Mendez March, who has been here twice as long as Rima, hit out at Nancy Liu, who's been here since a teenager, hit out at, Lawrence Zunan and Francisco Hernandez, who have been...
And how much money has...
Yeah. Sorry?
That comes down to how much money has she got?
Yeah.
Because that's what it comes down to.
Well, here's also the other thing is she's also on the Māori Affairs Select Committee as well as the Justice Select Committee.
Well, do you know what? I would tell her to get the hell off those two committees because she's got nothing to do with Māoridom. She does not come to the marae. I've never seen her at Tūranga Waiwai. I've never seen her at Rātana. I've never seen her at Parihaka for the Rā. I've never seen her over in Tūhoi when they have their Rā over there for the Ringatu. Where the heck is she from? She's a nobody.
Yeah, from Takanini. Which, to be honest,
let's just put it down to it. She's a nobody because I never heard of her until the day I.
Yeah, no, she's so the electorate she represents is Takanini, and she in 2023 she was successfully elected. She also went and stood in 2020, but failed to win the seat. Yeah.
To the chair of the select committee why has she been on that panel? She hasn't got enough live experience.
Well, it's not actually her.
To live in New Zealand, let alone understand.
Yeah, I mean, put it this way. I mean, and also the other thing is, she has been admitted to the New Zealand Bar in 2014, according to Wikipedia. She was an executive manager of the Te Mahia Community Village, a transitional and emergency housing service converted from a former camping ground owned by her husband's family. It's quite interesting. I don't know because that last name of hers is her married last name. Her husband is called Roger Knuckle.
Knuckle. Right, yeah, okay. I'm not sure, but anyways, take this for an example. That woman that got her moko kauai and she's Pākehā as. She was Pākehā as. She got a moko kauai. And people went off at her because she got a moko kauai. And I did too. And when I heard that she got because of her husband's hapu allowed them to have it, but she used it to her advantage to enhance her business. That was not right. That was kino. And she had to take it down. But she can't take down her moko kauai. So, because she got it done, her hapu and iwi, because she's a part of the hapu and iwi of Kahunanui and all of that because of her husband, they made her go and learn te reo. They made her go into the marae and learn everything from the bottom to the top.
Yeah. Let's get
now
to
she can have
the next
conversation and te reo.
Yeah.
Well, let's watch the little bit of the waiata. There it is.
Sorry, folks.
This is my kōrero.
Guys, come on. Please don't interrupt on the floor. It's not the time for participation. Meeting is suspended. Please clear the room. Okay, thank you, folks. The meeting's restarted.
Okay.
He suspended Parliament because of the select committee, because I did a mihi to finish Nana because he said an amazing kōrero, like he has a heart and soul into that kōrero, and it was like it meant nothing to them.
Yeah.
And in Te Ao Māori, we go by wairua, and when the wairua such the he and the wihi and the wana just took over, and I had to respond as a descendant of Parihaka and a descendant of a migrant from another land, which I am on all sides of my whānau. But remember, my great grandmother's full-blooded Māori. My great grandmother is it states on her birth certificate that she is full-blooded Polynesian or Maori descent. But my great-grandfather, Alan Ringipapa Lewis, he's known as a half-caste or a quarter-caste because he's Irish Scottish Māori.
Yeah. Okay.
That's how they put it.
We'll wrap up today's select committee hearings, and we'll get to the bills that will be, get for you to put in your submissions coming up. You're ready to sit there and start typing in links, Stacey?
Yeah, I got them all ready to go.
Okay, let's fire off. Okay, the budget policy statement is due tomorrow, Monday the 3rd of February. That you can put in your 2 cents worth on that for Nicola Willis's next budget. The offshore renewable energy bill is due this Thursday, the 6th of February, better known as Waitangi Day. What a great day for submissions to be due on. The broadcasting repeals of advertising restrictions amendment bill is due on Friday, the 7th of February. The resource management consenting and other system changes amendment bill is due on Monday, the 10th of February. The crimes legislation stalking and harassment amendment bill is due Thursday, the 13th of February, and the crimes increased penalties for slavery's amendment bill is due on Thursday, the 13th of February. So those are the bills that you can go and start submitting on that are closing in the foreseeable future. And one we would also like to point out to is we are starting our first block of funding for Give a Little for our 2025 It's in the Ballot shows. I'm just going to post that in the chat link there, so you can do it. So we're starting off with an initial foundation of $10,000 to get the books rolling. We'll also be applying for council grants and that sort of thing. I have currently booked basically most of Greater Wellington. Horizons have been booked, and I'm starting on Bay of Plenty. I've had, and I have to be honest, it does feel weird when you ring Murupara, because their phone numbers have the same exchange number as ringing Levin, ironically, except they're 07 or 06. So that is on there. If you'd like to sit there and help us onto our funds, one of the things we can apply for council grants is bonds, because they are refundable.
Yeah.
So going on that particular part there. Can I thank Jordon for joining us on this urgency show about the Select Committee submissions, and thank you, Stacey, for stepping into Laura's shoes for the day instead of being our producer.
No problem.
It's great to actually see different members of the team showing that we can move the books around. We will be coming back here at 8 o'clock for our normal 8 p.m. show. We'll be covering the Land Transport Amendment Bill, which is still drug driving, and we're also covering the removal of Section 7AA of the Aoranga Tamariki Act. So if you want to watch those 2 bills, the speeches go for there. Some great news. There's no seat warmer speeches this week.
Sam, I've got a question.
Go ahead.
I've got a question. The New Zealand Equine Advocacy Network group, which Waka Kotahi is trying to stop us from having horses on public roads, on beaches, on, you name it. He wants us to stay in our paddock. And is that going to be a part of the transport? And
it is not in that particular legislation bill. That particular legislation bill is regarding drug testing.
Right. So is there a possibility of looking into that bill that I'm talking about?
If that bill does come across the table, yes, I am certainly open to sitting there looking at that. If that bill comes onto the table, goes into first reading, we can sit there and do something that can work with that on the show.
Fantastic. All right, well, I'm going to go and have my KFC because my uncle's just turned up from Wairarapa and brought me some KFC. So if you're not far from here, come along and have some KFC.
Oh, big blinking, and I'm off to Basin Noodle House, which is not far down the road from you.
Right.
Nice. Thank you, Jordan.
And it's lovely to see you. Stacey, really good to see you.
Same to you. Yeah. And yeah. We
have
will
a good
see
evening. Coming back in.
Ray's yelling out, "Hi, Jordan."
Yeah. So yes, we will go and see everyone. Laura and I will be back here at 8 o'clock. I'm not sure if we're going to get you on camera, Stacey, but I'm sure we're going to see you there either in front or in the background. And also thank you to the new viewers who have started commenting on there. Charlene, I noticed you're a new person who's popped up. There's another one that has popped up in there. Thank you for sitting there joining our show. And feel free to remain part of our audience base. So yes, we will head off with closing credits. Bye-bye.
Thank you for watching the Order Paper, your express ticket to the New Zealand House of Representatives. Every episode, we unravel the complex world of legislation, debate, and democracy. From bills to select committees, we've got it all covered. From our team of political commentators who will dissect and explain what's happened so you can remain up to date on what's happened in the Aotearoa, New Zealand Parliament. To support our channel, you can become a Patreon member at patreon.com/It's in the Ballot. The Order Paper podcast is brought to you by It's in the Ballot Productions, live at